Okay, good afternoon, everyone. Thank you for being here today. My name is Keith Slack. I'm the Global Program Manager for Extractive Industries at Oxfam America. And together with Public Citizen, we are sponsoring this briefing. And of course, with the support of Congresswoman Linda Sanchez and Congressman Raul Grijalva. I want to thank both of them very much for co-sponsoring the briefing today and helping us get this space to address this critically important issue of international investor protection clauses within trade agreements and how they negatively impact human rights and the environment. We are lucky today to have a panel of a number of distinguished speakers, and we'll be discussing three cases, one from El Salvador, one from Peru, and one from Ecuador. And this will provide clear evidence of the issues that we are concerned about in terms of the investor protection clauses of trade agreements. I will briefly just introduce our panel, and then ask each one to speak for about 10 minutes, and then we'll have time for questions and answers after that. So all the way down on my left is actually Manuel Perez Rocha from Institute for Policy Studies, who will be doing a translation for us. Next to him is Luis Gonzalez from the Unidad Ecológica de El Salvador, which is a Salvadoran environmental organization. To my immediate left is Jose de Chávez from Cooperación, which is an organization in Peru that works on human rights and environmental issues. And he's also the former Vice Minister of Environment in Peru. On my right is Lori Wallach, Director of Public Citizen's Global Trade Watch program, of course, well-known commenter on trade issues. And to my far right is Marco Simons, lawyer with Earth Rights International, which is an organization that works on human rights and environmental issues. So each one of our panelists will provide some information about these specific cases, and so we'll have some time for questions. So with that, I think that we will start off with Luis from El Salvador to talk briefly about the Pacific Rim case in El Salvador, which is a mining case involving a Canadian company using the Central American Free Trade Agreement. Oh, yeah, sorry about that. Okay, actually, we'll start off with Lori. Thank you for reminding me that. Lori will give us an overview of this issue and some of the specific things we need to be concerned about, and then we'll turn over to the specific case.
I'm going to do just, thank you very much, and thank you to the members of Congress. It's an honor to be here with our colleagues from the other countries whose laws have been the targets of these unfortunate investor state cases. I'm going to just briefly, to make sure everyone is caught up to speed, some people here are great experts on this, other people might be learning about it, just lay out a little bit about the rules, the investor protections under which these specific cases you're going to hear about have come to fruition. So these are specific cases that make it very vividly clear that the threat that environmentalists and human rights groups have worried about the investor protections, both in free trade agreements, NAFTA, CAFTA, the Peru FTA, and in bilateral investment treaties. It's a very similar model, that the threat's not hypothetical, because here are some cases that are very egregious environmental examples. But in addition, the fact that these cases are ongoing is also evidence that the different changes that had been made during CAFTA and during the Peru FTA negotiations and congressional debates have not foreclosed this problem, that more reforms are needed. And to that end, I want to just direct people, because I'm not going to have time to go through it, to a document that Sierra Club, Friends of the Earth, Public Citizen, IPS have put out that's called the Top 10 Problems in the U.S. Investment Rules Model that should not be repeated. Because as well as trying to figure out how we stop the continuing damage that's occurring under the existing rules, the second thing to think about, particularly for members of Congress, is how to avoid spreading these rules. And right now, the Trans-Pacific Partnership FTA is under negotiation, an 8-country Pacific Rim FTA that, unfortunately, right now, the U.S. is pushing for an expansion even further of these rules and to extend them to more countries, these same investor protections. So the basic overview of the things that are of concern are these agreements give substantive special rights and privileges to foreign investors. These are rules that are granted in the agreements, and the agreements require that each country shall ensure the conformity of its domestic laws, regulations, and administrative procedures with the agreement. So you, as the host country, having foreign investors, must provide certain rights and privileges to the foreign investors, and the foreign investors have certain rights. Number two, there's a very broad definition of to what kind of companies and what kind of investments these new rights and privileges would apply. And then number three, they're privately enforceable by the actual companies. This is called technically investor-state dispute resolution. And it's a rather unique system I will briefly describe where the actual company, who's the foreign investor, gets to actually sue the government directly to enforce these new rights and to demand compensation. So first, the broad rights. There are a variety of them, but the two of them that are most relevant that you will hear in the threads of these cases is one set of rights that is in technical terms called the minimum standard of treatment. There's a guaranteed minimum standard of treatment, which sometimes you hear MST. And what that means exactly is not well defined. It's a circular definition, and even after an annex trying to define it that was inserted starting with CAFTA, it's unclear what exactly it really means. This is a note, these are issues that are basically the practice of customary international law, which is the way that annexes lay out what it means is very vague, and there is a related concept called fair and equitable treatment, the FET standard, which is also not clearly defined. It's not sort of statutory, here it is, here it isn't. And the problem is that the way some of these tribunals have interpreted those rights that are guaranteed, it's come out to mean that if you change a policy that was pre-existent, for instance, you improve an environmental regulation, or you find out you have a new problem that you now need to make policy for, the very change in the pre-existing circumstances have been determined on their own to be a violation of that guaranteed fair and equitable treatment minimum standard. So it's a little bit of a problem of literally chilling in place the existing conditions at the time an investor arrived, when of course obviously things need to be changed in ways that can affect an investor. The second, and there are many more complications as I'm sure my colleagues will touch on, the second big issue for these environmental cases is the right for a foreign investor to obtain compensation for what is called indirect expropriation, or a government action tantamount to an indirect expropriation. Now, for folks who work on land use issues, this is what the wise use movement called regulatory takings. Generally not allowed in U.S. law. In U.S. law, you have to take all value of all real estate, real property, for all time. And you can do that with a regulation, then you can get compensation. But generally, you have to take the physical property under U.S. law to get compensation. Some of these tribunals have said that a company can get compensation if the value of their investment is thwarted, or their expected future profits are undermined because of a government regulation. It doesn't matter that the domestic company has had to follow the same rules. If it undermines the expected future profits of the foreign investor, they have this special right. And that's one of the issues Congress has repeatedly dealt with, which is this gives special privileges to the foreign investor relative to even the domestic company. So let's just say the governor of Peru decides they're passing a law. It doesn't matter if you're from Peru, from the US, or from Mars. If you want to do X thing in this country, these are the environmental or zoning or other rules. Should be the right of a sovereign country to decide. If you're a foreign investor protected by these rules, you have special privileges. And this issue of the unfair treatment has gotten actually the government of Australia so wound up that this very neoliberal government, through its equivalent of their GAO, did a study where they decided this was a distortion of the market. They will not have investor state, they will not have these foreign investor special privileges, and they will not put up with it for the Trans-Pacific Partnership Agreement, which is very interesting, because this is a country that's very in favor of free trade and is in favor of TPP. So then the second issue, broad definition. the kind of companies that can get in is very broad. And with Pacific Rim, we're going to hear the actual mining company is Canadian. Right before it filed a case using CAFTA, which Canada's not in, it reincorporated as a US firm. This is in itself a clear problem. Or you can have getting compensation because you didn't get a permit. It's not just having your real estate taken, which was the original point of these kind of rules. So for instance, there's the metalclad case, and there's a chart of all of the NAFTA, CAFTA, Peru cases out in the back that lists all of the status of them, where they're filed, how much has been gotten. In the metalclad case, not giving an operating permit for toxic waste dump that had been closed under Mexican ownership, the new US owner under NAFTA came back and said, you can keep them from opening it, but we have a foreign investor right. And they got over $15 million in compensation for the right of not being able to open it. The scope is very broad, and in the Renco case, one of the set of issues that's being claimed is not being given another waiver for an environmental cleanup that had been ordered for a long time, that had repeated waivers. That was a violation. So you can in your head think of the things that the US government would be doing. They're just normal business practices of trying to enforce your policies that suddenly become a violation. Then, and by the way, just as an aside, financial instruments are also covered. That's not at stake here. But given that the use of this system is growing, it's worth noting there's currently a German law firm who's out fishing for clients who believe their investment in financial products in Greece were undermined by the recent crisis, and looking for clients to try and sue the Greek government and investor tribunal to extract money for foreign investors in Greece. Then it's privately enforced. This is a system where individual companies can sue our governments outside of our courts using the trade agreement rules, not the laws. Tribunals of 3 private attorneys, not subject to any particular conflict of interest rules, meet, typically in a hotel room. They implement either World Bank or United Nations arbitral rules. The company picks one, the government picks one, and the 2 pick the 3rd. They are compensated by the hour. So the longer it goes on, unfortunately, it's a bad incentive to take jurisdiction and keep these cases going. And with these lawyers, they rotate between being the lawyer and the judge. So they are heard, basically, by